You all will recall Adam Lally, of course. Adam Lally was the first prosecutor to try to convict Karen Reed in trial 1.0. He was the lead counsel, the first chair, and he tried that case beginning to end. Now, of course, the jury was hung after trial 1.0, although the reports were that they were only hung on count 2, and really they wanted to acquit Karen Reed on count 1 and count 3. But perhaps because of the confusion they had in the jury instructions, it ended up being that they were hung on all the charges. So trial 2.0 was scheduled, and at that point, the Norfolk County's DA's office decided that they cannot trust this case with Adam Lally anymore, and they have to go hire a special prosecutor, Hank Brennan, and pay him north of $500,000. Well, the result was worse than when Adam Lally tried the case. But in that second trial, Adam Lally was relegated to second chair, where he got a very comfortable seat watching Hank Brennan try the case essentially beginning to end. Now, Hank Brennan is a decent enough guy, and he threw Adam Lally a little bit of a carrot and allowed him to question one or two witnesses of the more boring types of the scientists, DNA scientists, and things like that. Well, this is a different case. This is Myles King. Myles King is a case that Adam Lally was the prosecutor on, and there was a very important evidentiary hearing that just occurred yesterday, and they are in the middle of this hearing. So it's going to continue, and there are going to be witnesses like Adam Lally, who started yesterday, and his testimony is going to continue. I believe it's August 5th, and we're going to hear most likely, or should hear, from Michael Proctor. That's what his attorneys said, that he will show up August 5th, even though he did not show up for this date yesterday. But the attorney that represents Michael Proctor said that he will show up August 5th. So what happened in Myles King? What happened specifically in this case? Well, I don't know all the details of the case. I was trying to find some documents on the case, but from some of the very little reporting that I did hear, it seems that the prosecution should have a very strong case against Myles King, almost similar to what they have against Brian Walsh, when you have all those incriminating Google searches that he did, like how to dismember a body and things like that, how to get blood out of a wood floor, right? Those type of Google searches. But now, just like in the Brian Walsh case, where there's a very serious motion that was filed and is right now pending about whether all those Google searches are going to be suppressed because of a little issue called the Fourth Amendment. And because if you didn't do your job with the search warrants, well, that may happen that some of these things that you get from the search warrants, they're going to be suppressed. So we'll see what happens in Brian Walsh's case. But now we have some of the same players. You got Michael Proctor, you got Lieutenant Tully, and these are the same people involved in the Myles King case. So what happened here seemed to be very odd. And it's becoming less odd as we continue to watch more Massachusetts cases, because it seems like this seems to be a pattern or practice. So what happened here is that there were some search warrants that were obtained in 2021, or at least they were written or applied for. There's an application by a fellow named Michael Proctor, former Trooper Michael Proctor, who has recently been dishonorably discharged from his position. But his fingerprints are all over a lot of cases that he worked on. And this is one of the cases, Myles King. Now, Adam Lally was the one who was on the stand. And listening to his testimony, I didn't really know where to begin and end, because you really have to hear a lot of the questions and a lot of the hearing yesterday, which is not too long. It's like an hour and a half. And it really just continues and continues. There's no place to really clip it. You got to listen to the entire thing, because it just keeps getting more unbelievable as you listen to it. So what happened here is that there was search warrants that were written in 2021. And of course, it's mandatory disclosure. This is required. This is basic Rule 14 practice in Massachusetts. You got to turn search warrants over. You got to turn the affidavits over. This is like basic, right? This is automatic required discovery, which means that you don't even have to make a request for these discovery. Now, of course, any defense attorney worth his salt will do that, but these are things that actually the prosecutor has to turn over. So they should be very familiar with the things that they are required, mandatory disclosures. They should be very familiar with it. Now, again, there was a request. So this is how Adam Lally starts off talking about the search warrants. So he made a request. What happens is you make the request of the prosecutor. The prosecutor gets the request, or even without the request, he should understand that I have to turn over the search warrants. So he should really start assembling all the search warrants that were done in the case and begin to turn them over to the defense. Well, under questioning, it seems that he got 1.5 search warrants. Okay, so he asked Michael Proctor, I need the search warrants. He got one search warrant and then part of another one. which this is the part which, if anybody had to define, like if you had to get a Webster's dictionary, if you ask Yuri Buchanan about this Webster's dictionary, if you had to get one of those and you would look under red flag, what would be defined as red flag is partial affidavit or partial search warrant. What in the world does that mean? If you're an attorney and you're supposed to be getting this information from your client or from a police officer, definitely the prosecutor, right? And they give you half of anything. Forget about if it's a prosecutor, forget about if it's a detective, a police officer, when you have the Fourth Amendment involved, forget about that. If you're an attorney anywhere and you have to produce certain discovery and your client gives you half of something, that should prompt a follow-up question. Why are you giving me only half? What's in the other half that you don't want me to see? We cannot hide this. This is not going to end up well for us, no matter what case it is. Forget about when it's a criminal case, when it's a serious criminal case where someone's life could be taken away, his life, liberty, right? He could be sitting in prison for the rest of his life. Forget about that. Even a regular case. This should be alarming to any lawyer when your client gives you half of something that you ask for. Now, it's one thing if they say, okay, look, we need, all of your invoices for the past 4 years. And they give you all of the invoices for the past 2 years. And you say, okay, great. What's with the other two? We're still working on it. Okay, fine. But if they start giving you half invoices, that should raise like every red flag in the book. And you as a lawyer, no matter what the case is, forget about even a criminal case, whatever the case is, that should be right away saying, hey, we need to, so let's stop for a minute. We need to have a conversation here. Are you trying to hide some information here? What is going on? Why are you only giving me half documents? Right away, that conversation has to happen. Okay, even in civil work, this is what has to happen. When your client seems to be hiding information from his own lawyer, and why is this so important? Okay, the reason why this is so important is because when you're a lawyer, it is your bar number that is on the line. If you're representing certain things to the court, if you're turning over discovery and representing to the court, yeah, we're turning over all the discovery. That's what you say in court a number of times, as we saw play out, by the way, in Karen Reed's case. So if you, as an officer of the court, with a bar license, with your license on the line, and everything that you say, you have a code of professional conduct that you have to follow. And part of that is obviously making sure that you're being forthcoming and honest with the court. So if this is my license on the line, I am not going to start representing to the court that I'm complying with discovery when I know that you're turning over half documents. No. Okay. It's my license on the line. Yes, you're my client. I have to take care of you and I'm going to protect you. But guess what? I'm not going to jeopardize my bar license for this, my bar number for this. I'm not going to jeopardize that. There's no one case in the world that's worth my license. So when I start seeing these funny things going on, that's going to prompt a very serious discussion with my client, even in the civil world. What exactly is going on here? And if I'm not comfortable with it 100% ethically representing you, I'm done. Okay, I'm dropping the case. You can go find some other lawyer to do your dirty work. It's not worth it for me. I don't care how much you're going to pay me. I'm not doing anything that's going to put my license in jeopardy. By the way, before we even move on with this evidentiary hearing, I think it's important to note that you see, believe it or not, that in Massachusetts, when you make some sort of allegations like this, where troopers like Michael Proctor are sitting on evidence for years, these are search warrants in 2021, you know what happens in a normal court? An evidentiary hearing. That is what happens. This is why the entire legal community was up in arms when there was no evidentiary hearing held in Karen Reed's case. Because we don't even know what's in these search warrants, right? We don't even know. It could be that these are not inconsequential things. It's possible. We don't know. We do know that in Karen Reed's case, there was very important exculpatory evidence that was sat on by Michael Proctor. We know that. Therefore, at the very least, like I've said, and I've been screaming into this camera for who knows how long, that of course you have to have an evidentiary hearing. It's not a question. Of course you have an evidentiary hearing, and it's complete obvious error not to have one. And this is why you see in this case, where we don't even know what's in those search warrants, from all that we're hearing, is that the evidence is really, really strong that Myles King, perhaps performed those charges, or is guilty of those charges, or should be convicted of those charges. And here in Karen Reed's case, where there was some very, very important Sally Port videos, which were just sat on by Trooper Proctor, and in the opinion itself, with Judge Cannoni's opinion in her order denying any evidentiary hearing, there's so many jumps to conclusions, so many apparentlys, so many, well, I guess this is what happened. And that's what we try to avoid. So it's nice to see at least should be a little comforting for some of you people that are living in Massachusetts to see that there are certain judges and certain courts that do allow evidentiary hearings to occur so that they can get to the bottom of this. So maybe that will give you a little bit of comfort seeing that, because again, this is one of the strongest issues with Karen Reed's case in front of Judge Cannoni that I could not for the life of me wrap my head around. I could not understand how you don't have an evidentiary hearing in the Karen Reed case. But again, it's nice to see that it's actually happening in other cases like Myles King. Okay, so let's move on. So the first red flag that has to go off in any lawyer's head, and we're not talking about a new lawyer on the block. We're talking about someone who's been prosecuting cases for years. There's Adam Lally. He's been on this case. He's been on cases for years. Hundreds of trials he's tried in district court. He's testified to. Right? So you got this guy, this lawyer, who's getting a police officer who he's asking for all the search warrants, and he gets some sort of piecemeal of a specific search warrant. It's not just he gave over 2 and says, oh, I have to go look at the other computer or look at the other file to get you the other 4. This is like half of an affidavit. I don't know what that means. Which half? I think that should have been a reasonable question to follow up. Which half of the affidavit are you talking about? Like, which paragraphs were included, which weren't? Was it the top half? Was it the bottom half? Was it what the signature part? Like, what does that even mean? Half of an affidavit. Okay, so that's just number one. Now, another interesting thing that came out was the fact that in the grand jury, and this is really troubling, in the grand jury, so he was asked, okay, so well, if you never got these search warrants, what did you present to the grand jury? Right? He only got 1.5 of 6 search warrants. So what did you present to the grand jury? And what he said was that, well, he presented that, these were the search warrants that were applied for. And this is the information that they obtained because of the search warrants, but they didn't actually produce the search warrants. But he said that there were 3 that were associated with cell phone records that, as part of what the cell phone, and this is what sometimes it happens, by the way, when you send a subpoena, when you use a search warrant to an entity, so with their production of documents, they will also attach the search warrant, which is requiring them to produce it. So they did. So Adam Lally said that, well, that is something that we did have at the time. So these 3 search warrants were attached to the production of those cell phone records, and that the grand jury did have. But the other 3, or maybe 2.5, I don't know. But the other ones he was just referencing, that's my understanding, he was referencing that these are the search warrants that were obtained. That's what he told the grand jury, and they were filled out. Okay, and now also, even on top of that, even if these 3 search warrants, even these 3 search warrants that were provided to the grand jury, the application was not provided. This is just the eventual search warrant that was eventually the order. But the affidavit was not provided of what Trooper Proctor put in there to get the search warrant. That wasn't provided to the grand jury. And that's still not provided. That was not provided to the defense. Okay, so that was just another interesting thing, that when you are the prosecutor and you are presenting information to the grand jury from search warrants, which you know are out there, or you've been told were out there, but you never saw the actual search warrant, that itself is, hold on a minute. Is this actually a proper charge? Should this person have been indicted if you're referring to search warrants that you never saw yourself? Okay, but moving on. Then he was asked at some point, how do you keep track of, what information is being requested, what type of discovery is, mandatory that you have to turn over, what you did turn over, what you didn't turn over? How do you keep track of all this stuff? And what Adam Lally said was, well, he has a list. Okay, now stop right there. Stop. What does that mean, you have a list? Does that mean you have like a yellow pad that you have a list, and each page is a different case? When you're handling 10 cases, maybe you can operate like that. When you're handling, let's say, like a prosecutor at a DA's office, which you may have 100 files. What is that? You have a list? Where do you keep the list? Do you have case management software? Like if you're handling 100 cases, 50 cases, if you're handling that, you need to have some sort of case management software that tracks everything. And when you are using case management software, like I've just said in this last video, every single thing that you do on a file must be documented and must become part of that file. You send an email, it gets attached to that file. Different case management softwares do it differently, but that's the point. You want to know everything that goes on in that file. And because you got, let's say 50 cases or 100 cases, if you're just going to rely on your head or rely on a yellow pad, things are going to get dropped all the time. So that's why they created these case management software. So is that something that the DA's office has? I think that's a worthwhile question, something that should be explored perhaps at the next evidentiary hearing. Does the DA have case management software? If they do, tell us about this list. There should be some notes there, right? You can have a notes tab in the case management software on that file. And in that notes, you can say, okay, list of discovery that we turned over or are still waiting on. So I don't understand what it means that he had this list. Like weird. Was it a Word document? What, where, how? I need to know more information about this list. And she kind of came back to this a little bit, at some point says, oh, didn't you say you have this list? So why aren't you referencing the list? And it just seems like everything's just completely disorganized over there. I don't even know if they have case management software, but what exactly is going on there? This really has got to make you stop and say, what's going on there? Okay. But anyway, so he's got this list, right? All right. And in this list, he's supposed to be keeping track of what he's turning over for discovery and what he's not turning over for discovery. Now, at some point, he keeps getting requests to turn over the search warrants, right? I mean, these are important documents. The search warrants, the affidavits, the applications, everything associated with the search warrants she wants. This is the defense attorney, right? And she's never getting them. She got 1.5, or maybe that's what Lally had 1.5. I'm not sure if he turned that over. I'm assuming he did. So now what happens is that he actually goes and meets with Proctor. At some point, he actually meets with Proctor because there was a motion for discovery. What do you know? Motion to compel discovery. Right? When you're not getting discovery from the other side, you file a motion to compel discovery. And after this motion to compel discovery, Adam Lally gets this motion and he's like, oh, okay, we better turn this stuff over. So he goes to actually meet with Proctor and he tells Proctor, hey, I need these 6 search warrants. You're still not giving it to me. These are months going by with me requesting. And he said that he followed up at least with 5 different emails, between 5 and 10 emails, following up, hey, I need those search warrants. I need those search warrants. I need those search warrants, and completely getting ignored. Then he goes and meets with Proctor. And then he says, okay, I need the search warrants. So Proctor says, okay, I'm going to get them to you. All right, great. You'll get them to me. Guess what? Did he get them to him? No. So I need some more information about that also. Okay, again, I need some more information about that. You're going to meet with Proctor. Now, like I said before, if this already happened, so if this is where I have a client, and again, we can take this out of the criminal courts if you want, because this would never fly, even in civil cases. And this is with any reasonable firm out there. You got a client, you keep getting requests for discovery, and these are mandatory disclosures. Okay, we're talking about mandatory disclosures, which are a little bit different than discovery requests. Now, it doesn't mean you can ignore regular discovery requests, but you can fight back a little bit more. We're talking about mandatory disclosures, which means that there doesn't have to be a request. And you go to your client, you say, look, we filed this case. We need these mandatory disclosures. We need the invoices or whatever, right? We need to turn these things over. And they don't. And then you follow up and you follow up and you follow up and they don't. Then they don't. And then you call the client in for a meeting. Okay. Now, if you're a lawyer who has any sort of backbone at all, and forget about a backbone. I mean, again, this is your license on the line, right? You're going to be the one standing up in court representing this client. So you get that client in the room and you say, listen, sir, I'm not doing this again. You're giving me this information or we're dropping the case. I'm not playing games with my license here. Okay. You wanted me to file this case. I trusted you. I looked into, some of the due diligence that I've done. It all looks like it's panning out, but I need this information and I need to turn it over now. I'm not just going to say, okay, all right, I'm sure you'll get it to me. No, this is going on long enough. I'm not leaving this office or we're not having this meeting unless you're bringing all of this information that I need. You want to play these games, you go to a different lawyer. Okay. That's not the way I practice. If I've been asking you for documents and you're not giving them to me and they're mandatory disclosures, which means I can get sanctioned, you can get sanctioned, I can get disciplined. I'm not interested in this. Okay. I don't care what number you're paying me. I'm not doing this. So that's even in the civil arena. Now, this is criminal, which is, well, you have someone facing prison time. And you have a police officer who's playing these type of games. You go down to the office, you sit with Proctor, you say, listen, trooper, I'm not leaving here until you give me these 6 search warrants. These are the subject of mandatory disclosures. You've been pushing these off for reasons that I don't know, which I should have already had 25 red flags, but I ignored them for whatever reason. Now I need you to give me them, and I'm not leaving until you do. What's the big deal? I'm in your office. He maybe went down to the police station and said, go get them. Go get them in the file. Look at the file right now. I'm not leaving. This is my license on the line. I'm not doing this. All right. Well, again, according to Lally, well, he met with him, said, okay, turn it over. And I just trusted. Yeah, I trusted Michael Proctor that he would do it, because why wouldn't you trust somebody who has been ignoring you for the past year and a half in turning over search warrants? I mean, of course, he's just going to turn it over tomorrow because he's someone who just really listens to you very closely every time you ask him for something, right? Because in the past year and a half, when you were asking him for search warrants, he was giving them to you, right? No. So just, a little bit of more common sense here and say, okay, maybe you don't have control of all the police officers when you are working for the DA's office. Okay, but fine. You go in there and you just make it very clear. This is my case. Okay, I know that you're working the case. It's got my name on it. And therefore, I'm running this case. I'm running this prosecution. I am the one in charge here. I know you have a badge and a gun, but I'm the one who's prosecuting this case. You have to listen to me. And I'm telling you to do something right now. You got a problem with it? Then I'll go speak to Tully, your supervisor, and I'll make sure that he gets it now. And if you guys don't give it to me now, I may drop this case, okay? Because I can't prosecute a case where you are going to play all these games. That's it. You just have to be the one in charge if this means anything to you. Okay, so he just ignores it, and that's why we are where we are now. These are search warrants that were written in 2021, and then Lally didn't even realize till 2025. And then there's this new ADA who's involved now. She's also going to be taking the stand apparently, but we're just getting started. We are just getting started with this evidentiary hearing. So if we have another situation where this guy, Myles King, who from all accounts seems like it's a Brian Walsh type of situation where it seems that the person may have a very strong likelihood of conviction, and because of these silly issues gets dismissed, this is a problem. You don't want these type of people to be roaming your streets, right? So this is what we're facing again. We got the same situation with Brian Walsh. Now we have it now with Myles King, and it's concerning. So at the one point, there's a little bit of comfort that we're actually having an evidentiary hearing, which is probably one of the most ridiculous rulings in the Karen Read case. There's 2 that I can think of: the Crosby issue, the fact that there was no Daubert hearing, and this motion to dismiss that was filed where you had very clear exculpatory evidence that was being hidden by Trooper Proctor. Nobody knew a lot of information about that situation, and Judge Cannone just said, nah, we don't need an evidentiary hearing for that. So at least the comfort of that there is a evidentiary hearing happening in this case, that's a good sign. But these type of shenanigans that's going on over there, like, is there case management software? What does this list mean? What does it mean that you got a half an affidavit and that didn't send every single red flag up in your mind? Like, what in the world is going on there? So, yeah. Well, let's talk about what could possibly happen in this case. So they started talking about a little bit of this at the end of the hearing, and that is whether there's prejudice in this case, because again, it comes down to what was in those search warrants. If you get late disclosures and these really Brady material, a lot of times, what is the sanction? The sanction for a Brady violation is a new trial. That is what the dismissal is generally not a Brady violation unless because of whatever these search warrants produced and they were not turned over, maybe you lost contact with a witness. Now a witness went missing that you could have tracked down if you would have gotten these search warrants before. and seen everything that was going on with these search warrants, maybe you would have been able to find some sort of witness. And now that you can't get that witness, now your case is prejudiced. Now you start having a case for a dismissal. Now, the other part is prosecutorial misconduct. Okay, so the Brady violation, again, we don't know what's in these search warrants. If they were immaterial, if it wasn't important information, well, then, it's just a big problem, the way that they prosecute the cases. But is it going to end up in dismissal? No. And then the question is, okay, what about prosecutorial misconduct? And here's where it gets interesting. Because even a lawyer himself or herself like this, and, you trusted the cops, and you got 100 files going on, and, this wasn't malicious. This wasn't intentional. This was just you dropping the ball and not realizing, using your common sense to realize that there's something odd about getting half an affidavit or things like that. Or when you're meeting with Proctor, not telling him, okay, go get your file and make sure I get those 6, search warrants. So maybe you can make an argument, well, there's no malicious intent here by Lally. This is just, a guy who's, kind of going through life. There was no malicious intent, right? Or maybe I should say everyone's favorite word at this point, nefarious. So maybe you'll say that about Lally, but it doesn't stop with Lally. And this is what should have been clear and was clear in the Karen Reed case. It doesn't stop with the prosecutor. It's the entire prosecution team. If some detectives are doing things that are malicious, if they're intentionally hiding search warrants or affidavits that they use to apply for search warrants for specific reasons, and they intentionally are trying to hide that information by not turning it over to Lally, now you have a case for prosecutorial misconduct, because it doesn't end with the prosecutor. It's the entire prosecution team, which includes all the detectives. So we still don't know the answer to that question in the Myles King case. We still may find some more prosecutorial misconduct. We're just at the beginning of this evidentiary hearing. We got Adam Lally to finish up. We got this new ADA. I forgot her name. We have Michael Proctor taking the stand, and Lieutenant Tully taking the stand. There may be some other people taking the stand, and that's going to continue. I believe it is August 5th. So that is the story of what happened yesterday. Again, some Norfolk County, Massachusetts stuff rearing its ugly head. And that is going to be it for today. So if you haven't yet, please subscribe and like, and we will see you next time.